Welcome to Wills, Estates, and What Comes Next, Probate Insights with Jamie Cuzmar.
Welcome to Wills, Estates, and What Comes Next, the podcast where Florida families get clear, compassionate guidance through estate planning and probate. I'm Zofia Morales, and I'm here with attorney Jamie Cuzmar, founder of Cuzmar Law Firm. Whether you're planning ahead or navigating the legal process after losing a loved one, this show is here to make complex topics feel understandable and manageable. So let's get started. Today's topic is what to expect in a Florida probate case. Welcome back, Jamie. I'm happy to have you here with us.
Thank you, Sophia. Always a pleasure to see you.
So let's start with the fundamentals. For someone who's going through probate for the very first time, what should they know right away?
So probate can seem overwhelming at first, but it's essentially the legal process of transferring assets from a deceased person to their heirs or beneficiaries. So the most important thing to know is that probate ensures, one, the descendants' wishes are honored, and two, the second component is that debts get settled. So it's crucial to stay organized and seek professional assistance to navigate this process smoothly.
Can you break down what the probate process looks like in Seminole County? What's the process? What's the step-by-step? And how do you know if you have to go through it?
Yeah, we talked about this in a prior podcast, mainly being that there's two types of probate, the formal probate and the summary probate. So here I'm going to talk about the formal. So in Seminole County, probate begins with filing a petition with the court to open up the estate. So once the judge approves it and opens up the case and assigns a case number, then the court appoints a personal representative to manage the estate. So typically in the petition, the personal representative or the petitioner will seek to be the personal representative, and the judge can approve that or assign someone else. So this also involves gathering assets, paying debts, and possibly taxes, and then distributing the remaining assets to the beneficiaries. So each step kind of is a little meticulous and requires some documentation and, of course, adherence to legal rules to ensure the process goes smoothly.
So what are some of the common challenges or delays that families run into as they go into this probate process?
So one of the biggest things I see is families facing challenges from other beneficiaries or other siblings or members of the family. That's a big part of it. So it's best, of course, to have a will. I think we're going to talk about that later in the segment. But locating all assets, dealing with creditors' claims, and of course, delays can also occur due to incomplete or inaccurate paperwork. So again, it's essential to communicate openly and work with your attorney to overcome these hurdles and try to expedite the probate process.
So what I'm hearing is there's a whole lot of paperwork here. And if it's not done right, you get into trouble.
Yeah, or it slows down the process. So, a probate can typically last, several months to over a year. So the more information that is missing, the longer it's going to take. So you can't just kind of throw stuff up in the air and hope that it sticks. You have to go through a process, answer some very specific questions. And so the more organized you are in the beginning, the faster the process will go.
And how do you help families stay organized and reduce the stress that goes with this process and keep it, streamlined and on track?
So we provide support by offering clear guidance. So one of the things we do during the intake is provide the necessary steps, inform the client that the more detailed records they can provide up front. There's a little bit of a questionnaire component to that as well. So we'll give them kind of a questionnaire of things to expect, things to produce, and of course, ensuring timely communication between both parties helps a lot. So we'll also break it down into timelines. And so by breaking down the complex tasks into manageable pieces or smaller chunks, so to speak, and addressing the concerns promptly or asking for the right information. For example, the death certificate, that's one thing that's necessary to open up the case. And in that sense, we can help the family stay organized and reduce the stress during probate.
Yeah, and I like that you break the complex down into like little manageable pieces. I know the last several years I've had an unfortunate amount of experience with the phenomenon they call grief brain. And yeah, small bite-sized tasks are about what I can deal with when I'm in that space.
Yeah, so I mean, a lot of people, like you mentioned, with the grief brain, sometimes they're on medications to be able to handle these hard times and grieving the loss of a loved one, depending on who that family member is. It could be a few weeks before they're kind of understanding the process clearly.
So, is there anything that people can do ahead of time to make probate easier for their loved ones? I know in some cases you don't have much of an opportunity to do that, but sometimes you have a heads up. You're sick, you've got a bad diagnosis. That will light a fire under a person.
Yeah, so absolutely, there's some ways to make it easier for your loved ones, especially creating a well drafted will. So, keeping a will on hand, letting your family members know where it's located. That way, they can find it, or even filing it with the court ahead of time for safekeeping. That's also an option. So, beyond drafting
Ah,
a well drafted will, also keeping an updated list of assets. So, that's important too, because part of the probate process. Uh, One of the things that makes it last longer is if the family doesn't even know what assets to seek or to request from the court. If they don't know that this person banks at a certain place, or they don't have they don't know that there's a life insurance policy, and that can delay the process, because if it has to be thrown into the mix after the probate's already started, it requires additional paperwork to amend the petition. So beyond that, the will and keeping an updated list of assets, thinking about designating a trustworthy personal representative, of course, can significantly ease the process. So thinking of these things in advance definitely will move things forward. If you have a well laid out plan, of course, think of a Lego kit. You're building a car with Legos. There's basically, directions 1 through 100 or whatever it may be. So considering those steps ahead of time is going to put your family at ease and be able to handle that process a lot easier than if those directions weren't in place. Additionally, discussing your estate planning with your loved ones can, prevent misunderstandings. So it's not something to shy away from. It's a good idea to have these conversations to ensure everybody's on the same page.
yeah, and I like you mentioned a few things in there that it's like, ooh, that's a nugget right there. And filing your will with the court, I didn't even know was possible, but I would imagine that prevents post demise shenanigans from going on with the will.
Absolutely. And in my own practice, I recommend it for individuals that are, say, already retirement age, or for those individuals that feel like there's family members that don't have their best interests in mind. Because when you get up there, a lot of times later on, you might not know exactly what's going on if you happen to get dementia or Alzheimer's. So that in those particular cases, I always recommend that they go ahead and file it, or have me file it with the court for safekeeping if they're not sure they're going to be all there in the future years.
Yeah, exactly. You mentioned earlier when we were discussing the probate process that the court will assign a personal representative. And it's oftentimes the person that brought the case for the probate to be opened who's seeking that role. What does that role really entail? How do you support them? And what are the odds that the court will choose to assign them or to go with someone else? How does that play out?
Yeah, so the primary role the personal representative is in managing the estate. So that entails gathering assets to pay possible debts, and then, of course, distributing anything left over or the inheritance to the loved ones or the beneficiaries that may be on the will. So we support personal representatives by providing, of course, legal advice, assisting with the paperwork, and ensuring that they fulfill their duties efficiently and accurately. So a lot of people don't really know, what those duties are. So we'll go ahead and have a meeting to discuss those things so they know what to expect and whether they truly want to fulfill that role. Because sometimes people are caught off guard, like, oh, wow, I don't really necessarily want to be responsible for these things.
Yeah,
So that
and I
comes
had
up.
no idea how involved and time consuming this might become. How involved and time consuming does it become? I guess that's a good question.
Well, it kind of goes back to how accurate the paperwork is, but also whether or not the deceased person left behind the manual or a will specifying these things, who they elect as a personal representative. If there is no will and there was no personal representative elected to begin with, then the court will usually decide, or the petitioner can make a case as to why they should be in charge of the estate. So usually it's somebody closely related. Think of a spouse of a deceased person. If there's no spouse, then possibly a brother or sister of the deceased.
Is there any reason the court would kind of toss that person out? Are there any disqualifying factors?
Yeah, it used to be that the personal representative would have to be in state or a resident of the same state. Think of the times when people didn't have transportation as readily available as they do today. So that's no longer the case. You can be an out-of-state resident and be the petitioner or personal representative of somebody else in Florida, even if you don't reside outside of Florida. But besides that, it has to be a relative that's closely related and a non-felon. So if you have something on your record, then you may not be able to fill that role or be assigned that personal representative role because you might not be as trustworthy as you need to be.
So you laid out the process, and I think you kind of brushed over a time frame. Let's really dive into that. How long does probate take, and what speeds it up and slows it down?
Yeah, so the duration varies. Again, if it's a formal probate, that's typically on the 9 month to a year, over a year length. The summary ones can take anywhere, I would say, about 4 months approximately, sometimes less. It just depends on factors such as the assets that you're trying to retrieve and also what debts may be left behind. So a typical summary probate with an asset, say like a life insurance policy that didn't name a beneficiary and there's no debts involved, and it's pretty clear cut who that's owed to, maybe the spouse of somebody that passed away, and that could take, less than a few months. Other factors, for example, such as complexity, disputes between beneficiaries, and of course, the efficiency of the personal representative providing the info requested can influence the timeline. So again, things like clear communication and proper planning ahead of time, and of course, seeking the professional guidance of an attorney can expedite the process a little bit.
Speaking of expediting the process with an attorney, are there any pitfalls that personal representatives should be aware of that some professional guidance could help them avoid?
Yeah, I mean, there is some cases where people are trying to represent themselves, but if you go to try to check your county court website, it will stress to you, hey, it's not as easy as it seems. Please seek guidance of an attorney. But there are some cases for the smaller probates, like the summaries, where it's possible for them to print out a few documents and start filling in the blanks. But I've had people take a look at that and said, hey, if you're interested in trying this, because they didn't want to pay maybe the retainer fee or the cost that it takes to represent somebody in probate, there are some self-help documents out there, particularly in the county court websites. But when you start looking at the questions that it's asking, they are highly technical, so they might not know how to answer it. And of course, if you try to self-represent and write in something that's not adequate or misleading, it's going to get kicked back. And so the clerks take a look at all those answers that are filed with this documentation, and they'll kick things back if it doesn't make any sense or if there's something that's missing. So that can delay the process quite a bit. It's not impossible for the smaller ones, but the formal ones, definitely, I haven't seen any cases where somebody has gone through it on their own.
Very good. Well, thank you for all the insight around this. This has been very helpful.
No problem. I hope that this reaches people that need it and can find suitable guidance and professional representation, whoever it may be.
All right. And thanks for listening to Wills, Estates, and What Comes Next. For more information or to get in touch, visit kuzmarlaw.com. And if you found today's episode to be helpful, be sure to subscribe, leave a review, and share it with someone you care about. And we'll see you on the next episode.
See you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.